So friends, we have two big court hearings scheduled for Monday. Donald Trump's D.C. trial date will be set, and Mark Meadows' mockery down in Georgia. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, we have two big court hearings scheduled for Monday, one in D.C. and one down in Georgia. I'll be attending the court hearing in D.C., that's here in my backyard, my old stomping grounds, Federal District Court in downtown D.C. After it's over, I'll be posting a video here on my Justice Matters channel trying to give you the color commentary, the inside baseball, what I saw, how the hearing played out. As you may know, Judge Tanya Chutkan is presiding over Donald Trump's D.C. prosecution. You know, that's the one for Trump trying to overturn the results of the 2020 presidential election. He's facing 4 criminal charges, 4 felony charges. And Special Counsel Jack Smith has requested a sensible trial date, a speedy trial date, January 2nd, 2024, this coming January. And you may recall that Donald Trump's lawyers have asked Judge Chutkan to kick the trial down the road about 2.5 or 3 years. April 2026, well after the November presidential election. So, you know, that way Donald Trump can just have his attorney general dismiss the case against him in the extraordinarily unlikely event Donald Trump becomes president again. Rest assured, he won't. And there's also a case down in Georgia, you know, Mark Meadows' follies down there. And we're going to talk a little bit about that, but I want to start with the case in D.C. There are going to be two things that I'm going to be looking out for tomorrow. One, the obvious one, what trial date will be set by Judge Tanya Chutkan. I have a feeling she'll set an early 2024 trial date, perhaps January 2nd, perhaps February, March, maybe even April. But I think she understands that not only does Donald Trump have a right to a speedy trial, which he is more than happy to waive. He doesn't want a speedy trial. He wants the exact opposite. But she also understands that we, the people, have a right to a speedy trial. We deserve to have these charges resolved promptly and well in advance of the next presidential election. The second thing I'm going to be looking out for is whether Judge Chutkan takes up the fact that Donald Trump violated the conditions of his pretrial release in his federal case. How did he do that? Well, when I was in court watching in what's called the overflow courtroom, there was a closed circuit that was broadcasting from the arraignment court, which was a very small courtroom, into an overflow courtroom. So I got to watch Donald Trump's arraignment in real time. The magistrate judge who was presiding over that hearing told Donald Trump, and I quote, "Sir, the most important condition of your pretrial release in this case is that you not violate any federal, state, or local law. Do you understand? If you violate a condition of release, you could be arrested, you could be revoked on release, and you could be jailed pending trial. Do you understand that, Defendant Trump?" And what did Donald Trump do? Within days, he violated the terms of his pretrial release. How? He posted that, "I know a witness is about to appear before the Georgia State Grand Jury." This is before District Attorney Willis had the grand jury return the indictment against Donald Trump and his co-conspirators. He said, "I know that former Lieutenant Governor Jeffrey Duncan is supposed to testify before the grand jury, he shouldn't. He shouldn't testify. That violates Georgia state law, which prohibits influencing or attempting to influence a witness in an official proceeding. So what I will be keenly interested to see in Monday's court hearing is whether Judge Chutkan will call him to the carpet for that. Say, look, we told you the most important condition of your release was that you not violate any state law, and you violated a state law. Indeed, you did it in writing. I've got your post right here, Defendant Trump. Will she take that on? Will she, do everything she can to maintain the integrity of the criminal justice system, to hold accountable a defendant who's on pretrial release and refuses to abide by the conditions of his release? I sure as hell hope so. Because the integrity, indeed the very legitimacy of the criminal justice system depends on judges enforcing their orders, their release orders prohibiting misconduct by folks who are on pretrial release. I can't say I'm 100% confident that she'll take it up, but boy, I sure hope she does. And what I will say is I do have complete confidence in Judge Tanya Chutkan. You may have heard me say previously that I used to try murder cases against Tanya Chutkan when she was an assistant public defender in Washington, D.C., and I was an assistant United States attorney trying murder cases. I hold her in very high regard. So I will bring you the blow-by-blow. I'll bring you the color commentary as soon as that hearing concludes on Monday. But now let me turn for just a few minutes to Mark Meadows' mockery, Mark Meadows' folly. Because down in Georgia, Mark Meadows is one of 19 charged co-defendants, co-conspirators in a RICO case, because he was part of a criminal enterprise together with Donald Trump and others, designed to try to interfere in and overturn the results of the Georgia state presidential election. And what has Mark Meadows done? He's filed a motion in federal court. Now, this is a Georgia state prosecution saying, wait a minute. I think my case should be transferred from state court to federal court. Why? Because when I was engaged in this criminal conspiracy, trying to interfere in the Georgia state election, I was acting within the scope of my official duties as Chief of Staff to the President of the United States. Anybody with a lick of sense knows that is nonsense. But that's the claim he's made. So Monday will begin the evidentiary hearing in whether Mark Meadows' case should be transferred from Georgia State Court to federal court because he was just doing his job as the Chief of Staff. I am keenly interested to see what kind of evidence Mark Meadows produces at this hearing. Brad Raffensperger, that's the person who Donald Trump and Mark Meadows were on a phone call to, trying to coerce him, corruptly threaten him to come up with enough fictitious votes to just corruptly declare Donald Trump the winner of the Georgia state election. And Mark Meadows was on there pressuring Brad Raffensperger as well, talking about fictitious votes that didn't exist and urging Raffensperger to, just throw the election to Trump. I'm interested to see what evidence Mark Meadows will produce. We know Brad Raffensperger has been subpoenaed by the prosecution and will testify for the prosecution. Maybe Mark Meadows is going to call other chiefs of staff to other presidents of the United States, and they will be able to say, well, yeah, see, it's written right here in my job description, my duties as chief of staff, right here. Interfere in state elections. Try to corruptly convince state election officials and state government officials to unlawfully keep the president in power even though he lost the election. It's right here, my official duties. You get the sense of how absurd Mark Meadows' claim is? So what kind of evidence Mark Meadows will produce, saying that even though state elections are uniquely and exclusively the province of the states, Chief of Staff to the President gets to interfere, gets to intervene, gets to urge state election officials to just change the vote count in favor of my boss. So once the evidence plays out, it will probably take some time. I don't know if it will be a matter of days or weeks before we get an answer. Couple of little bits of silver lining behind the big dark cloud that is Mark Meadows. First of all, the state case proceeds even while Mark Meadows is in court trying to convince a federal judge to transfer the case from the states to the feds. The judge happens to be a judge named Steve Jones. He was appointed by President Obama about a dozen years ago in 2011. He's a highly regarded judge, so I'm confident he's going to get this call right. But the state case will proceed while Judge Jones decides this issue. The other good news is, even if the judge grants the motion to transfer the case, it is still a state case. It's a state case that gets prosecuted in federal court. It's a state case that gets prosecuted by the state court prosecutors. District Attorney Fani Willis and her team of prosecutors. It doesn't magically convert into a federal case. Why is that important? Because a federal pardon won't work. You can't pardon Mark Meadows or anybody else who gets convicted in a state case in violation of state law, even if those state charges get transferred to federal court. So, there is a silver lining there in the unlikely event Meadows' case does get transferred. There are a lot of other legal ins and outs that come along with a transfer that I'm not going to bother unraveling here because I don't think it's going to happen. But if it does, we will get back on topic and we'll talk about the implications of a federal case, of a state case being transferred to federal court. But friends, primarily what I'm going to focus on over the course of the next 24 hours is Donald Trump's hearing in federal district court in Washington, D.C. before Judge Tanya Chutkan, because I have a feeling we're going to have some good news to report about Donald Trump's trial date in his federal prosecution in D.C. I have a feeling Judge Chutkan fully appreciates our right to a speedy trial. Because justice matters. Friends, as always, please stay safe. Please stay tuned. I can't wait to talk with you tomorrow.